This reasonable likelihood of payment test looks to the ability to pay of the obligor, and the REITs will need to consider how to determine whether they satisfy the test and have a recourse debt allocation.
Joining me today is Andrea Whiteway, Principal with EY. Thank you so much for joining us today.
Thanks for having me.
Now, you were on a panel here at REITwise focused on partnership tax issues. What issues do REITs need to be aware of regarding partnership liability allocations?
The first set of regulations are anti-abuse rules that were implemented in 2019. And those anti-abuse rules set forth factors that the government can look at to recast a recourse debt obligation as non-recourse. And then the second part of that anti-abuse rule was a requirement that there be a reasonable likelihood of payment by the obligor of that obligation in order for it to be respected. This is of particular relevance to UPREIT structures, because in an UPREIT structure, the REIT's only asset is its partnership interest in the operating partnership. And that partnership interest in the operating partnership, typically if an operating partnership has recourse debt, the REIT is relying on the recourse debt being allocated to them as the general partner. This reasonable likelihood of payment test looks to the ability to pay of the obligor, and the REITs will need to consider how to determine whether they satisfy the test and have a recourse debt allocation. The second set of regulations that are relevant are regulations that were issued as temporary regs effective October 5th of 2016. And those regulations were subsequently finalized, but they provided a 7-year grandfather relief. The regulations dealt with bottom dollar payment obligations, so a bottom guarantee or a bottom deficit restoration obligation. Those arrangements, if they were entered into on or after October 5th of 2016, would not attract a share of recourse debt unless the partnership and the partners decided that they would like to rely on this 7-year grandfather relief so that new arrangements entered into during the 7-year period would attract a share of debt equal to your negative tax basis capital account as of October 5th of 2016. Now, that 7-year period seemed like a generous grandfathering relief, but we're now in 2023, and October 5th of 2023, those arrangements will cease to attract a share of recourse debt. So REITs that have bottom dollar payment obligations in place with their partners need to review their obligations to those partners under contractual undertakings, if they will owe them a make-whole, if they cease to have a share of debt allocated to them, and also consider if there are other techniques available to get them a debt allocation. The ones that currently are blessed by the regulations include a vertical slice obligation, so a vertical slice guarantee or a vertical slice DRO. The devil's in the details as far as drafting those arrangements, but you can certainly continue to get a debt allocation through one of those techniques. But something that they need to consider in the next few months and enter into to the extent they're relying on a grandfathering.
Now, are REITs using more joint ventures now compared to historical norms as an alternative way to raise capital? About
between 5 and 10 years ago, we saw this trend where public REITs were forming joint ventures with sovereign wealth funds and foreign pension funds because they saw it as an attractive cost of capital. The public markets were not valuing the REIT stock at where they thought it was fair from a net asset value perspective, whereas the sovereign wealth funds and foreign pension funds perhaps were giving them more credit on the net asset value, and you also got to collect fees in those JVs, investment management fees inuring to the benefit of the REITs. I haven't really seen that trend yet, but it may well be that transactional flow has slowed down, and I think once the debt markets settle out and interest rates level off, we might see an additional trend there, because obviously sovereign wealth funds and qualified foreign pension funds have a lot of capital that they are still looking to deploy.
And finally, can you talk a little bit about the differences you've experienced practicing in a Big Four accounting firm compared to being a partner at a law firm?
Sure. So I practiced in the big law for close to 25 years, and I've been at EY for 7. I think the obvious differences are in a law firm, you have much more of a day-to-day direct contact with your client, and you're involved in the transaction from the very beginning to the very end. You're involved in all the negotiations, the drafting of the legal agreements, and structuring, drafting, and then presumably issuing opinions on the back end. In the accounting firms, we don't draft, we don't practice law. So that's been one of the starkest differences for me, is not having that day-to-day connection. Now, I will say from the substance of what we're doing on a daily basis, I think the questions are much more sophisticated, the issues are much harder, and we typically only get brought in when it's a really thorny, difficult issue. And I think that the talent that I've seen in the accounting firms is bar none. The caliber of professionals that they have there, experts in various areas, resources, really has been invaluable to me.